This is Jeff J. Brown, China Rising Radio Sinoland, and this is the second expose I have done about Huawei and its CFO Meng Wanzhou. The first one was a lot of work. This one was many times more work. I mean, a lot of work, days and days of work. I hope you will show your appreciation for my anti-imperial writing and make a contribution to PayPal, Patreon, or fundraiser. I could probably make a lot of money if I set up a website and trashed Donald Trump and praised Biden and Obama and the Clintons. Anyway, please make a donation, $1, $5, $20, $100, whatever you can do, especially if you can do a monthly pledge on PayPal or Patreon. I would really appreciate it. I'm excited about this. This really exposes some hard truths about Western justice. It is not fair that Huawei CFO Meng Wanzhou landed in Canada, can't have Perry Mason as her lawyer, and be tried in his mythical world of rule of law, such as life. Pictured above, Raymond Burr as defense attorney Perry Mason in the long-running eponymous American television court drama. In spite of seemingly insurmountable, nail-biting odds, he almost always proved his clients were innocent. A fictitious character living in the mythical world of rule of law. Note before starting, this is number 2 of a 4-part expose covering Meng Wanzhou and Huawei. Here is the first one, and it is entitled Explosive Expose Blows the Cover Off Huawei Meng Wanzhou's 2018 sting operation in Vancouver, Canada, the truth and consequences of connecting the dots, and of course that link, and I mean there must be 50 or 60 links in this thing, so get to the original web page on China Rising if you can. All right, this one has many subheadings, and so I'll just say subheading. Subheading, Calling Perry Mason. When I was a child growing up in the United States, there was the incredibly successful courtroom drama television series Perry Mason, 1957 to 1966. British Columbia, BC native actor Raymond Burr brilliantly played the eponymous part of a criminal defense attorney who relentlessly sought truth and justice for the wrongly accused. During each weekly episode's trial, Perry's bloodhound secretary and private investigator would doggedly find evidence to refute the gullible, headline-seeking Los Angeles District Attorney, the DA, who only wanted a guilty verdict. As the courtroom drama proceeded, witnesses for the prosecution and defense were called to testify in front of the keen-to-know judge and jury of peers. When it looked like all was hopeless and Mason's innocent victim was surely going to wrongfully go to the electric chair, he would ensnare the prosecutor's star witness in a web of lies, then go to his briefcase to dramatically pull out heretofore just dug up proof of his client's innocence, often leaving the real culprit on the witness stand breaking down in sobbing tears or screaming in rage from the gallery as the camera panned in on their tormented, "You will burn in hell" face. Perry Mason would then pass by the prosecutor's courtroom desk, offering the DA a droll, reassuring riposte to set up the next week's episode. This went on for 9 years and 271 shows. First picture, the ancient Greek goddess of justice, Themis, maintaining the iconic scales of fairness inside the atrium of the British Columbia Supreme Court. The myth of blind justice has never been the case anywhere in the world, going back to Mesopotamia's foundational Code of Hammurabi 4,000 years ago. Subheading: Meng Wanzhou's World. Unfortunately, Huawei CFO Meng Wanzhou, still under 24/7 guard and house arrest in Vancouver, BC, now for 2 years, doesn't have Perry Mason as her defense attorney, nor does she live in that fictitious above politics and justice is blind world. Too bad Raymond Burr's mesmerizing BC screen bravado can't magically free Ms. Meng from her Sino-Canadian-American geopolitical predicament. Where is Perry Mason's slam dunk evidence when you need it? Meng can only hope that it does not take 271 trips to the courtroom to finally get there. While 9 TV seasons is a stretch, her whole potential U.S. extradition hearing could drag on for several more years if it gets that far. Subheading: Canada's pathetic examination of discovery. Before 1963's U.S. Supreme Court Brady versus Maryland decision, government prosecutors could withhold evidence that proved the innocence of the defendant. Thereafter, pre-trial discovery became, some would say, idealized standard operating procedure, SOP, since countless cases over the interim have shown Brady to be violated. In Canada, this SOP is similar, called examination of discovery, and given the realpolitik of all judicial systems, is just as compromised. Behind the rule of law fig leaf, Canada offers its government and prosecution lots of avenues to avoid evidential discovery. Codified after the 1991 Canada Supreme Court case R versus Stinchcombe in 2014, in 2014, after 1991, Canada finally passed its principles of disclosure. Section 5 is entitled Exclusions, and here is where Meng Wanzhou finds her predicament. You don't have to be a lawyer to see that the subsections entitled 5.1, Police Informers, 5.2, Reply Evidence, 5.3, Ongoing Investigations, 5.4, Investigative Techniques, 5.5, Cabinet Confidences, 5.6, International Relations, National Security, National Defense, 5.7, Solicitor-Client Privilege, and 5.8, Work Product Privilege, make a mockery of Canada's examination of discovery. This is how BC Supreme Court could, with a straight face, give Meng's attorneys pages and pages of documents that were so redacted and blacked out as to be nearly meaningless, and how many more were never revealed because of Section 5. With very broad and vague evidentiary exclusions, Section 5 makes it easy for the BC Supreme Court, judges, prosecutors, the Canadian Border Services Agency, the CBSA, and Royal Canadian Mounted Police, the RCMP, to play off of each other. Thus, they can, quote, legally, end of quote, hide any cooperation and collusion amongst themselves, including with the U.S.'s Federal Bureau of Investigation, the FBI, and the Department of Justice, DOJ. Pictured above, Canada's Extradition Act is routinely derided as wrongful. Subheading: Canada's Medieval Extradition Act. Furthermore, to add insult to injury to Meng Wanzhou, Canada has what is considered to be one of the most pro-extradition laws in the world. Its Extradition Act can be branded medieval. The United States didn't even have to offer sworn testimony. Canada will simply accept a foreign representative's word as, quote, presumed reliable evidence, end of quote. As in, trust me, she's a witch. On top of all the massive exclusions in Section 5 discussed above, Canada's 1999 Extradition Act lowers the bar even further, making it perfectly suitable for the star chambers of the Spanish Inquisition. 1. Prosecutorial evidence can be hidden. Number 2. Political interference is allowed. Number 3. The accused cannot question the foreign representative who, number 4, hasn't even had to swear to the truth. And 5, the defendant can be denied presentation of evidence or proof that they are innocent. Pope Sixtus's Grand Inquisitor, Tomás de Torquemada, would blush at such lenient terms for conviction. Pictured above, Hassan Diab Center with his lawyer Don Bain, left, and hijab-wearing wife right outside the courthouse in Ottawa. Was he railroaded for being a Muslim Arab? New subheading, rigged evidence is just fine in Canada. Ask Hassan Diab. Canada's Extradition Act is routinely branded as a legal disgrace, as the case of Hassan Diab shows. This Lebanese-born Arab Muslim, Ottawa University sociology professor, was arrested by RCMP in 2008 at France's request on a supposed 1980, quote, synagogue bombing case, end of quote. In 2011, the Canadian judge overseeing his extradition stated that the evidence was, quote, convoluted, very confusing, with conclusions that are suspect, end of quote. Furthermore, adding that the prospects of conviction in the context of a fair trial seem unlikely, end of quote. In plain words, the judge knew Diab was being railroaded in a framed-up case. Nonetheless, Canada's Extradition Act gave him no option but to order sending Diab to France. In 2012, apparently bowing to the same law, the Minister of Justice approved Diab's extradition. There, he was imprisoned for 3 years, including solitary confinement, whereupon the evidentiary fraud was exposed, and he was released to return home. He and his family are now suing the Canadian government for $90 million, but 10 years of their lives have already been destroyed and cannot be gotten back. Subheading, Meng is on the same Canadian judicial conveyor belt to perdition. In effect, Meng is guilty until proven innocent, and there is not much she can do to support her case. If the BC Supreme Court decides that she should be extradited, Meng is in one of the worst countries in the world to keep it from happening. The U.S. Department of Justice can even show fraudulent evidence, commit perjury, and Meng's judge has to accept it as, quote, presumed reliable evidence, end of quote. Pictured above, PowerPoint pages number 6 and number 16 from the Huawei presentation that Meng Wanzhou gave to HSBC, the bank, in 2013 in Hong Kong, showing the company's full compliance to the USA's unilateral sanctions against Iran. How convenient they were omitted by DOJ's request to Canada to apprehend her. This can be found. I created a Meng Wanzhou plus Huawei online library, and the link is here. I've got tons of stuff. Continuing on, some journalists have pointed out that the U.S. DOJ omitted 2 key pages, number 6 and 16, from Meng Wanzhou's infamous Huawei prepared 2013 HSBC PowerPoint presentation, which DOJ used to support their demand for extradition. It was these two slides which clearly show that Huawei was not violating the USA's unilateral sanctions against doing business in Iran, whose presentation, the whole presentation can be seen on the online in the online library below. Yet with Canada's Extradition Act, this kind of rigged evidence, just like for poor Hassan Diab, is perfectly acceptable. Diab's travesty of justice is one of the most well-known, not to mention Meng's. Nevertheless, there are a number of others. The Extradition Act has been on the books for 21 years and counting, while being branded by many Canadian legal scholars as, quote, wrongful, end of quote. Therefore, Diab's nightmare story fully projects to Meng Wanzhou's case, meaning she will almost certainly be extradited to the United States if Canada decides as such, and there is almost a 100% chance of that happening, given Canada's, in parentheses, IL, end of parentheses, legal, as in illegal foundations backing it. She can ask the Minister of Justice to halt it and then take it to the BC Court of Appeals, like Diab did in Ottawa. His appeals were rejected on both counts. When Diab then went to the law of the land, the Supreme Court of Canada, they refused to hear it, sealing his Kafkaesque fate. Not only its Extradition Act, but the geopolitical nature of Meng's case is even more high profile than Diab's, given Canada's well-known servile role as a weak vassal state in the hierarchy of the U.S.-led Western Empire. Can we expect anything more promising for Meng Wanzhou? Next subheading. 6 other countries refused to capture Meng, but not imperial vassal Canada. Knowing that all Canadian cases can be extradition cases can be a grotesque mockery of fairness, transparency, and due process, one has to wonder if the United States bided its time until she traveled there to have Meng apprehended/kidnapped. However, it has been reported that U.S. DOJ had previously asked 6 European and Latin American countries to do the same thing, yet they all refused, including staunch American allies. This thereby confirms Canada's ever obsequious role as a U.S. flunky. My northern friends, with painfully wry smiles hanging on their faces, euphemistically call their country, quote, little brother, end of quote. For Meng to say that Washington holds all the cards, including as many jokers as they want to add in the pack, is a gross understatement. As researched and shown in my previous expose, the Yankee fix seems to have been firmly in place in Canada from the get-go. At the initial extradition hearings, following her CBSA and RCMP capture/kidnapping at Vancouver Airport on 1 December 2018, her lawyers pro-offered their first of now 4 claims for, quote, abusive process, is what it's called, which, given its medieval Extradition Act, is the only avenue defendants in Canada have to fight the foreign request. Pictured above, from a CCTV video outtake, Meng Wanzhou walking in front during her arrest at Vancouver Airport on 1 December 2018. Subheading, Meng's 4 claims of abusive process. Number 1, arrest at airport was illegally conducted. The first claim of abusive process entails Meng's arrest. Since court hearings and testimony of CBSA and RCMP officers just ended, this one will be discussed later in the expose. Next subheading, abusive process number 2. The Canada-U.S. extradition treaty should matter. Their second claim for abusive process pointed out that under the Canada-U.S. extradition treaty, see online library below, I added it, a defendant cannot be sent to the USA if the crime they are accused of is not applicable in Canada, stating Section 46, Paragraph 1, the minister shall refuse to make a surrender order if the minister is satisfied that A, the prosecution of a person is barred by prescription or limitation under the law that applies to the extradition partner. In extradition law, this is known as double criminality. The U.S. charged Meng and Huawei of committing fraud with HSBC Bank for violating America's unilateral sanctions against Iran. There was only one problem. Canada had already rejected USA's Iran sanctions and in fact was doing lots of business with the Islamic Republic. There can be no fraud if there were no internationally recognized UN sanctions. Pictured above. Left, 1905 bigamist George Collins' BC extradition case was used for Meng Wanzhou's case. Justice Holmes was used for Meng Wanzhou's case for Justice Heather Holmes to throw out one of Meng's claims of abusive process. Even with Canada's Kafkaesque Extradition Act, this abusive process really hit the double criminality mark and should have been all the evidence needed to send Meng on her merry way. So BC Supreme Court Associate Chief Justice Heather Holmes, who presided over her case, had to dig deep, really deep, to deny it. Her May 2020 ruling, which was called United States versus Meng BSCS 2020-785. I also have that in the online library. Excavated an obscure 1905 BC case which approved the extradition back home of an accused U.S. bigamist where he was living with his, quote, secret wife. The BC judge, Lyman Duff, 150 years ago admitted defendant George Collins' bigamy was not an extraditable offense. Nevertheless, in San Francisco, Collins had purportedly lied during a civil court process. Perjury, and that was based simply on the unconfirmed testimony of the prosecutor in San Francisco, ruled that Collins should be returned home, where he was sentenced to 14 years in prison. Using similar tortured language, Justice Holmes opined, quote, first, economic sanctions laws such as were in place in the U.S. at the time of the ATP, which stands for Authority to Proceed, are not part of Canadian law, but they are also not fundamentally contrary to Canadian values in the way that slavery laws would be, for example. You know you're desperate when, in 2020, you have to invoke slavery to justify your reasoning. Further reducing Canada's judicial independence and global sovereignty to a spineless blob, the justice stated, quote, Canada's law of fraud looks beyond international boundaries. Ms. Meng's approach to the double criminality analysis would seriously limit Canada's ability to fulfill its international obligations in the extradition context for fraud and other economic crimes. To make matters even more embarrassing, Holmes really got her judicial panties wound up in a twisted knot, claiming, quote, the essence of the alleged wrongful conduct in this case is the making of intentionally false statements in the banker/client relationship that put HSBC at risk. The U.S. sanctions are part of the state of affairs necessary to explain how HSBC was at risk, but they are not themselves an intrinsic part of the conduct. End of quote. Notwithstanding, even if Meng and or Huawei had lied to HSBC, which evidence shows to be untrue, it would be a simple professional matter between two commercial parties. Lying to your customer/supplier may be dishonest, but it is not a crime. These kinds of disputes happen all the time in the business world, ending in cessation of relations and or arbitration, nothing more. In throwing out Meng's abuse of process number 2, Holmes spoke like a supine imperial lackey. Subheading, abusive process number 3. Meng's arrest was a political seizure. Even the Canada-U.S. Extradition Act says so. Meng's next claim of abuse of process was filed in July 2020 and went after the politicization of her case. On 11 December 2018, just days after Meng's apprehension, U.S. President Donald Trump said he'd be happy to use her as a bargaining chip to win a better trade deal with China. He told Reuters, quote, "Whatever's good for this country, I would do. If I think it's good for what will be certainly the largest trade deal ever made, which is a very important thing, what's good for national security, I would certainly intervene if I thought it was necessary." They, in parentheses, Chinese President Xi Jinping's staff, end of parentheses, have not called me yet. They are talking to my people, but they have not called me yet, in parentheses, about Meng's case. Again, this should matter. The Canada-U.S. Extradition Treaty states in Article 4.1.c, and I quote, "When the offense in respect of which extradition is requested is of a political character, or the person whose extradition is requested proves that the extradition request has been made for the purpose of trying or punishing him for an offense of the above mentioned character. If any question arises as to whether a case comes within the provisions of this subparagraph, the authorities of the government on which the requisition is made shall decide." Quote, "If questions arise," end of quote, "can let the USA decide if deferred to. And knowing Canada's kowtowing inability to exert its sovereignty, this is not promising for Meng. Even still, Canada's Extradition Act says the same thing. In quote, 46, Section 46, Paragraph 1, the minister shall refuse to make a surrender if the Minister of Justice is satisfied that C, the conduct in respect of which extradition is sought, is a political offense or an offense of a political character." Does the U.S. capturing Meng to extort her to reveal commercial secrets and demanding her extradition to extract trade concessions from Huawei and or the Chinese government look like, quote, "of a political character," end of quote, to you? It sure does for me. Or is Meng simply on the wrong side of geopolitics? In a country where rule of law truly meant something, the above would be cause for concern. But in Canada, it is just hollow, glorified rhetoric. Justice Holmes, likely under intense imperial political pressure to toe the line, has yet to render a decision to Meng's second claim of abusive process. Pictured above, the BC Supreme Court with its stylish modern architecture. Subheading, abusive process number 4. Meng's seizure violates commonly accepted international law. The fourth claim of abusive process was just submitted right after the termination of the CBSA and RCMP testimony hearings, which ended the third week of December 2020. Contextualizing two news releases, They said, this claim takes a global perspective. International law does not allow a government to criminalize the conduct of someone who isn't a citizen outside of its own jurisdiction, where there is no genuine connection to that country. HSBC is incorporated in the United Kingdom. Meng is a Chinese national, and the alleged misrepresentation on unilateral U.S. sanctions were made in Hong Kong. There is no connection between Meng's alleged conduct and the United States. The bank's clearing of U.S. dollars was not necessarily a, quote, reasonably foreseeable consequence, end of quote, of Meng's actions. None of Meng's alleged conduct occurred in whole or in part in the U.S., nor did it have any effect there. Consequently, the United States' assertion of jurisdiction is unlawful. Meng's prosecution is premised on foreign financial institutions using U.S. correspondent banking services in violation of U.S. sanctions for which Meng is not responsible. Such charges give effect to U.S. economic policy abroad and are thus contrary to common international law. The emphasis I made written emphasis, give effect to U.S. economic policy abroad. That was the end of what the lawyers are claiming as abuse of process number 4. All of this is true and should matter enough to get Meng released, but remember, we are in medieval vassal Canada. The other chink in this claim is that Western countries in general and the USA in particular routinely flout international rules, regulations, laws, UN resolutions, and the United Nations Charter of Non-Interference in other countries' domestic affairs. Sadly, it seems that exceptionalism and extraterritoriality is about all they do. Again, the U.S. making most of the headlines, even attacking and sabotaging its own imperial allies. With the USA as self-nominated imperial globocop to invade, occupy, and plunder the world's weaker states, steal and pirate assets, sanction and embargo thousands of entities and people across the globe, why would a measly common international law get in its way while continuing to bully and browbeat sycophantic Canada? Canadian legal scholars have weighed in saying that Meng's abuse of process number 4 should be taken directly to Canada's Minister of Justice, as the Extradition Act gives this cabinet-level post the power to refuse sending someone on, further on to the other country, with adequate evidence. Worryingly for Meng, in spite of the judge in Hassan Diab's case saying the evidence against him looked phony, the Justice Minister at that time, Rob Nicholson, still sent him to his doom in France. If gutless Canada cannot even say no to second-tier imperial wannabe France, can we expect the current head of justice, David Lametti, to stand up to their southern master? Pictured above, Meng left, likely sitting next to an interpreter, listening to her lawyer, Richard Peck, make a statement on her behalf to BC Supreme Court Justice Heather Holmes. Next subheading. Now back to Meng's abuse of process number 1, illegal arrest. One has to keep from guffawing at the extensive court hearings which took place at the BC Supreme Court on and off in November and December 2020. Not even redoubtable Perry Mason could win, with all the CBSA and RCMP officers falling back on the infamous Nixonian "I didn't do it," and numerous permutations of those hoary chestnuts. "I don't recall. I forgot. He said, she said, I did not say. I have no idea. It was not me. Everything done was reasonable, normal, routine. Coulda, woulda, shoulda, ad nauseum." Meng has been a legal Canadian resident since 2001. But yes, her 3-hour pre-arrest grilling and seizure of all of her and her travel companions' electronic devices, quote, was just a routine border check, end of quote. Taking careful notes like all good law officers are trained and expected to do, yet we repeatedly got, quote, I regret not taking any notes, or I should have taken more notes, or my boss told us not to write anything down, or emails were my record keeping. When Meng's lawyers have been denied multiple internal CBSA, RCMP, FBI email communications, or what they got was heavily redacted to near uselessness. Pictured above, RCMP Constable Gurvinder Dhaliwal, the officer in charge of Meng's electronic devices, testifying in court. He's really very, very sorry. Next observation about the court hearings. CBSA used FBI-supplied anti-static bags to seal up all of that seized hardware while we heard, quote, the FBI wasn't a factor, end of quote. This while turning over to RCMP all the e-goodies with the passwords extracted from Meng before her arrest, and it was, gosh, we're really sorry what happened, and it was a heartbreaking mistake. Or the FBI repeatedly called, quote, veteran, end of quote, CBSA Passenger Operations Chief Nicole Goodman, but the latter promised she didn't divulge anything. Next picture, Ross Lundy giving his very forgetful testimony. Next one, RCMP Sergeant Ross Lundy conveniently failed to make any mention of the FBI in all of his notes, nor in his legal, what's called will say, W-I-L-L and then S-A-Y. Notwithstanding numerous emails from RCMP Financial Crimes Unit clearly stated that he was the key contact for the FBI. Cornered by Meng's cross-examining lawyer, Richard Peck, Lundy had to confess, at the end of the day, I was identified as a contact in the case, and she, the local FBI legal attaché, contacted me for updates. I wonder what all was not written down. What did Lundy want to hide? Next image. Sanjit Dhillon loves to use Wikipedia to find out all about the people under questioning. CBSA Superintendent Sanjit Dhillon, quote, became suspicious about Meng being a spy and Huawei undermining the Canadian government after checking her out for only 5 to 10 minutes on Wikipedia. This in spite of Wikipedia being notoriously inaccurate and full of disinformation due to trolls and censors. I guess Dhillon forgot about Dr. Tanner Ockham. CBSA consulted Wikipedia when Ockham arrived in Montreal in 2007. Based on fake slander presented therein, he was detained by CBSA for several hours, ready to throw him in jail. It took high-level Canadian government officials to get him released. Too bad Meng does not have any of those connections. How many other hapless travelers have been railroaded into wrongful convictions based on the CBSA and RCMP consulting Wikipedia? If you have a Wikipedia page and plan on traveling to Canada, beware. Next picture. CBSA border agent Salmath Katragada just couldn't recall key evidence during his court hearing. CBSA border agent Salmath Katragada told one of the lawyers representing the USA in Meng's hearings that during her 3-hour pre-arrest, quote, immigration, end of quote, grilling, CBSA's National Security Unit demanded that she be asked for more information. Katragada conveniently could not recall the questions and of course took few notes, only remembering to get a list of all the countries Meng visited. In sum, do we laugh, cry, or both? Is this what passes for the West's greater-than-thou, chest-thumping rule of law? Poor Meng. I'd much rather be tried in a Chinese court any day of the week. Incredibly, Meng's farcical Keystone Cop hearings hit even further bottom. New subheading, incomplete to the point that you have misled? And the picture, CBSA's Nicole Goodman outside court. She was on the ropes and ready to cough it all up, but was stopped by U.S.-appointed lawyers from doing so. CBSA's Vancouver passenger operations chief Nicole Goodman was apparently feeling troubled about her withering hours-long cross-examination by Meng's lawyer, Mona Duckett. Continually being challenged about the truthfulness of her testimony, Goodman frequently choked on her words and broke down in tears. As a father who raised 2 children and someone who had to question many students during my years of teaching, this kind of behavior is not a good sign. Judge Holmes had already instructed Goodman to not discuss her testimony with anyone, which is exactly what she did. Outside the courtroom, Goodman's unease seems to have driven her to ask an uninvolved government attorney about her testimony and whether it included privileged information. This got back to Mr. John Gibb Carsley, a Canadian government lawyer representing the USA in Meng's case, and who was then compelled to inform Justice Holmes, Meng's legal team, and Canada's amicus curiae, Mr. Anil Kapoor, a Toronto lawyer who has top secret clearance and is tasked with making sure nothing concerning national security is divulged. Upon hearing what happened, Holmes told Goodman to go have a brief chat with Kapoor, who spent 70 minutes alone with Goodman to get her story straight. Coming back out, Kapoor gave Goodman wiggle room a mile wide, saying she should, quote, completely and truthfully answer to the best of her recollection, end of quote. And it was, quote, up to counsel to raise objections, emphasis mine, which, not surprisingly, is exactly how it played out. Miss Duckett got Goodman back in the witness chair, zeroing in on her being, quote, incorrect or misleading because you were not being complete or truthful, end of quote. In other words, lying. Goodman came back with an equivocating incomplete. Duckett retorted with incomplete to the point that you have misled? Thereby, Deus ex machina. Deba Majzoub, another Canadian government lawyer working for Uncle Sam, objected. How convenient. Incredibly, this U.S. objection was granted, claiming Duckett's question entered into, quote, litigation privilege, end of quote, for several civil lawsuits filed by Meng and Huawei. Because Meng's lawyer asked if Goodman had lied? Meng's team had no choice but to agree that Kapoor would again meet with Goodman, known as massaging the testimony. And gatekeeper Kapoor would decide what to tell both law teams what he learned from Goodman. You can't make this stuff up. Of course, the U.S. team couldn't be bothered, as they certainly had all the evidence that Meng's side was and is still being denied. We can assume that Kapoor cherry-picked Goodman's evidence into one long non sequitur, while the prosecuting members worked hard to keep from grinning. Then again, maybe they did. And it must be asked, did Nicole Goodman directly disobey Justice Holmes on purpose? Was she put up to it? Her testimony up to that time sure seems to demonstrate that she was lying and or withholding evidence, information that could have been very valuable for Meng, maybe to the point that she would have to be set free. Meng's attorney, Ms. Duckett, clearly had Goodman on the ropes for the knockout punch. Instead, the way it played out, Duckett's haymaker was strangled into nothingness. And then there's a picture of Ms. Mona T. Duckett, and the byline and the citation says, Mona T. Duckett, Meng Wanzhou's lawyer. I want her on my team. Even with Superman, Hulk, and the Fantastic Four on his team, Perry Mason would probably lose this one. Pictured above, Supreme Court Justice Heather Holmes and the printed cover of a British Columbia court case. Subheading, the case against Justice Heather Holmes. As if to underscore Canada's less than stellar legal system, the, quote, Canadian Committee for Constitutional Courts, the CCCC, a group working to clean up the country's judicial corruption and cronyism, lists Justice Heather Holmes as a crooked judge. This is what the CCC has to say about her. When Austin Cullen was made a Supreme Court judge, he arranged to take with him another girlfriend from the Crown Counsel's office, namely Heather Holmes, who, along with Elizabeth Bennet, can be relied on to do dirty justice in cases that need to be fixed, such as the recent case where Justice Heather refused to allow a litigant to have access to court documents that would have disclosed how the system of justice in British Columbia is rigged from the inside and who is behind it, who is behind the rigging. Heather was protecting criminals and she knew it, and she was doing it with the approval of Austin Cullen. The criminals in the court system are determined to protect themselves. Credence to these is accorded to these claims as Mr. Joe Adam at legaljudicialblogs@gmail.com is not hiding behind anonymity. Another related website and its main page are even more scathing of Justice Holmes. More so, British Columbia seems to have a reputation for dirty justice, as several websites cover the subject. One, dead judges don't lie. 13 dead judges linked to one lawsuit suddenly drop dead. So I should say probably dropped dead. Number 2, the criminal conspiracy that destroyed BC lawyer Carl Icebrenner. Number 3, the Robert Stork story, janitor in search of justice. Number 4, the Shawnigan Lake Water War. Number 5, the water war crimes, Canada's biggest scandal. And the last one is British Columbia Justice Elizabeth Bennet, a corrupt judge. And I looked at all of them, and they've just got pages and pages of evidence. They identify themselves, and so they're not hiding behind, some fake, in the darkness. They're out there making these accusations where people can contact them. So is this sour grapes or something to consider? Canada surely has hundreds of judges presiding over cases across the country. The fact that out of all of them, Meng's judge is accused of being crooked is not reassuring. Did the U.S. DOJ make sure Holmes was the one chosen to take on Meng's case, knowing that she is compromised? It's very possible. Subheading, a summary. Meng Wanzhou is unfortunately caught in the vortex of a perfect geopolitical imperial storm. Her fate will be decided in the final extradition hearing this spring, projected to be wrapped up in May 2021. This is where her team will present and argue the 3 remaining claims of abuse of power left in their legal quiver, unless, of course, Justice Holmes is, in subsequent interim court rulings, peremptorily throws more claims out. All right, summary point number 1. Canada's Extradition Act is a mockery of fairness and truth, almost guaranteeing the defendant being shipped off unless the most unimaginable abuses of process can be exposed, and even that is far from any assurance for the person arrested. Number 2, Section 5, exclusions of Canada's principles of disclosure negates any meaningful discovery of evidence for the defense. No wonder Meng's lawyers are fighting with all arms tied behind their backs. Number 3, Meng's Vancouver airport apprehension on 1 December 2018 was clearly a travesty of justice. This is her abuse of process number 1 and has not yet been ruled on by Justice Holmes. Number 4, Meng's extradition is manifestly a case of double criminality, which is her abuse of process number 2. Judge Holmes had to gin up some really egregious legalese to deny this claim. Number 5, of course, her capture/kidnapping was and still is very political in the U.S.'s failed hopes to get Meng to sing, its quest to compromise Huawei, and diminish China Tech's unstoppable success. This abuse of process number 3 has yet to be ruled on by the BC Supreme Court. Number 6, Meng's abuse of process number 4, that the circumstances of her arrest and extradition trial are contrary to common international law, has not been ruled on yet. Be that as it may, Western Empire making a mockery of social justice, global justice, since at least the post-war period, not to mention 500 years of gangster colonialism, normalizes and banalizes terrible criminal precedents of exceptionalism and extraterritoriality. Number 7, Meng's CBSA and RCMP court hearing testimonies expose Canada's medieval Kafkaesque mockery of justice while ripping the death mask off of the West's mythical rule of law. And finally, number 8, Canada is a servile, vassal finger puppet of Western Empire, and the USA rules it with an iron fist. Canada's extradition laws, awful as they are, still afford the Minister of Justice the means to have already released Meng based on the abundant evidence at hand. The fact that this has not happened strongly suggests that Washington's imperial extortion, blackmail, and/or bribery are in full force in Ottawa. In closing, as we usher in 2021, the Chinese Year of the Cow, Meng Wanzhou's will certainly not be one full of milk and honey. Based on the evidence gathered in my 2 exposés, I predict that, and it really pains me to say this because I realize the injustice of it, Judge Holmes will rule Meng suitable for extradition to the USA. At that point, Meng can only drag out her appeal for as long as possible, hoping for a change in the geopolitical landscape or a noble, sovereign-minded Canadian government that can say no, at least this one time, to Uncle Sam. Hey, I wonder if Perry Mason's clients ever had to go through any of this. I guess I'd have to watch 9 years of box set DVDs to find out, but I seriously doubt it. And then there's the Meng Wanzhou Huawei online library, and then forthcoming exposés, number 3, HSBC, and number 4, the 2 Michaels, Michael Kovrig and Michael Spavor. Again, please show your appreciation by making a financial contribution to all this hard work at Patreon, fundraiser, and PayPal. So many thanks. Bye-bye.